It was entirely normal that the Attorney-General should bring it to the attention of the Court of Appeal, although he did issue a number of press statements, which is unusual. It's also unusual for the Attorney-General to handle this personally, because it's normally dealt with by his deputy, the Solicitor General. But what was extremely unusual today, what I've certainly never heard from before, was criticism by the Lady Chief Justice about the way that this case was reported.
We begin then with news that's broken this afternoon that two 15-year-old boys originally spared custody for the rape of two girls in separate attacks in Hampshire have now been sentenced to 4 years detention. The pair were given non-custodial sentences in May, but after a review, the Court of Appeals ruled that decision was unduly lenient. Let's talk to the legal commentator, Joshua Rozenberg KC. Good afternoon, Joshua.
Hello, Calum. Good afternoon.
It's good to speak to you. Just talk us through then what happened today, what this procedure was and the outcome of it.
As you probably know, the Attorney-General has the power to refer the sentence given in a number of serious cases to the Court of Appeal. There was a hearing yesterday where Lord Hermer KC was represented by a leading barrister, Tom Little KC, and the court also heard from senior lawyers representing three boys who were sentenced after this attack on two girls at Fordingbridge. And the Court of Appeal gave judgment this afternoon, Lady Chief Justice of England and Wales, Baroness Carr, and as you've reported, she decided that in the case of the two boys who were most involved, they should serve custodial sentences, and those would be 4 years. In the case of the third boy, who had a lesser involvement in the matter, his non-custodial sentence remains unchanged.
Okay. In terms of how this was triggered, there are concerns, Joshua, about how this procedure works. This was a case that attracted a lot of attention, a lot of outrage, and a lot of concern that the justice system hadn't performed its functions here. Is it unusual, I suppose, the way that this was brought then to the attention of the Court of Appeal, or do you think this was normal procedure at play?
It was entirely normal that the Attorney-General should bring it to the attention of the Court of Appeal, although he did issue a number of press statements, which is unusual. It's also unusual for the Attorney-General to handle this personally, because it's normally dealt with by his deputy, the Solicitor General. But what was extremely unusual today, what I've certainly never heard from before, was criticism by the Lady Chief Justice about the way that this case was reported. She said it's a matter of significant concern to us that these events have become a matter of intense public debate before the legal process has concluded. And listen to this. She said, the dangers of public comment by members of Parliament, the media and others on matters still proceeding through the courts and tribunals are self-evident, the most obvious being the risk of proceedings of the risk of proceeding on the basis of an incomplete or inaccurate understanding of the facts and the law. So she's criticising MPs and journalists who were commenting on the case without having heard from the judge. To be fair to the journalists, the judge did not issue sentencing remarks, as judges normally would do. And then, this is completely remarkable, she said the single most egregious example of this was perpetrated by a press release by the Crown Prosecution Service, which was responsible for the prosecution. She said not all media outlets have their own court reporters. It's of particular importance that the Crown Prosecution Service should ensure what they say about what happened is fair and accurate. But the Crown Prosecution Service published a press release that, which was not spontaneous or unplanned, but a formal press release which opened with the statement that the three offenders had been sentenced after they were convicted of a knife-point rape and other serious sexual offences. It went on to say that the second victim, the second complainant, had been threatened with a knife and forced to leave her mobile phone and AirTag in a shop so her movements couldn't be tracked. Both those statements were inaccurate, said the Chief Justice. On the judge's findings, there was no knife-point rape, and C2, the second complainant, had left her mobile phone and AirTag in a shop of her own accord.
Yeah. So all of that you've just outlined there, Joshua, by way of how unusual it is, do we have to wrestle with the law and procedure and practice being outdated in a world where online reaction is instant, it is often intense, it is often extreme, and actually MPs have played their part of that, the media may have responsibility in that too. Do we need to consider whether the law in this regard, and the restrictions I suppose, are fit for purpose?
What we need to consider is how judges handle cases of this kind. And what went wrong in this case was that the judge did not issue what are called sentencing remarks, a copy of his explanation for the sentences he passed to the reporters in court. It was made worse by the fact that the judge explained in simple terms to these young offenders what they had done and why the judge was passing the sentence. And then a lot of reporters simply left court to report this and didn't wait to hear his sentencing remarks, which, as I say, were not made available. Yeah. And what's worse was they weren't made available for 2 or 3 weeks because he had to come back from holiday and check the transcript that was made of his remarks. So it is possible to ensure that journalists and MPs and everybody else have a better understanding of what happened, but I don't think there's any need to change the law in this regard. It is, however, very important that the courts should explain to the media that it's important to report these things accurately.
Yeah, absolutely. Joshua Rozenberg KC, thank you very much. Thanks for your time.